Yes.
Adjournment request from item number 1 to 6.
Item 5, my lord. I'm appearing on behalf of the petitioner, my lord.
Yes.
Number 8, my lord. I want to file my lord
What do you want?
my lord.
What do you want?
I want to file my lord objection, my lord.
All right. You are appearing for the respondent.
Respondent number 8.
As per, yes.
Lordship, I'm appealing for the applicant. Lordship, a short time may be given. Lordship, we have some emergency.
Three
Lordship.
my lord.
Weeks.
Lordship.
As prayed for on behalf of respondent number 8, let this matter be adjourned to enable him to contest the application seeking condemnation of delay of 522 days. 2. What have I said? Pray for, as prayed for, re-notify this case on so and so date under the appropriate date.
22-9.
Public. Item number 1, we have to file objection, my lord.
You have filed an objection.
Yes, my lord. No, not file, but
You have not filed.
yes.
Objection to what?
A affidavit in reply we will have to file.
What is this for? Give us the file.
This is regarding the artificial flooding in Guwahati and related issues. Civic amenities in the Guwahati.
Regarding artificial flooding.
Lordship.
So, have you given any suggestion?
Yes.
What your
The progress we are giving, we have given it to agency. They are doing the work for redoing the whole drainage system. We are at the final
That's
stage.
right, but what is the council?
They want to
trying
file a objection. They want to file a counter.
Reply.
Counter for what?
We have filed some affidavit for some.
Maybe response. I should use the right word.
Put it on record, but then let us not, put any impediment in the work of, social, in social works. If you can add something to it, all right. All right. As prayed for on behalf of the petitioner, in order to enable him to make his suggestions to the proposal already given by the state for improving the artificial, for eradicating the artificial flooding in Guwahati region. The matter is adjourned to. Then we put it in October's.
Lordship.
24-10. Adjournment request from item number 7 to 10. From item number 11 to 20, adjournment request. From item number 21 to 48, adjournment request.
Lordship, I beg to mention item number 26, Your Lordship, on behalf of the appellant, Lordship. I've already taken the consent.
Lordship, I am on behalf of Senior Counsel Mr. Ram Juava S. Goel.
That's
Private.
right. You consent to this, no?
Yes.
Adjournment slip has
Yes.
already been circulated.
Lordship, can it be fixed after 4 weeks, Lordship? After 4 weeks, Lordship?
We'll see. Give a date.
4-11.
Lordship.
Highly obliged.
It is a lot. Lordship, I beg to mention item number 27, my lord.
27.
My lord, in this case, we are going to file affidavit in opposition today, my lord.
All right, as paid for on behalf of the respondent. Have you informed the other side?
My lord, he is
Indeed.
appearing. He is appearing.
As paid for on behalf of the respondent, let this matter come up for consideration also and so date.
29-10.
That's me.
May I please, Your Lordship? But with the consent of the other side, I beg to mention item number 46, 47, and 48. Lordship.
These are all tied up matters,
Tied up.
analogous matters.
Yes, Lord.
What about others? Are they agreeable?
Yes, Lord. In first two,
As prayed for on behalf of some of the appellants, some of the writ petitioners, consented to by the others. Re-notify all these set of cases on, give a date sometimes in October.
29 October.
So item number 29 to 48.
29 to 46 is different. He is
no,
making mention.
46, 47, and 48.
No, that's different. That's different. 46, 47, and 48 are not with these, no? No, sir. Sure. All right. So 46, 47 and 48, you have circulated the adjournment slip.
Yes, yes.
All right. So alag-alag करते हैं. All right, yes.
Regarding 29 to 45 also.
First, let the courtmaster give the dates for this.
Sure.
46, 47 and 48 separately.
31st October.
Yes,
Lordship, regarding 29 to 45, that series, Lordship, I have circulated the Lordship request slip, adjournment slip, Lordship,
29 to?
45, Lordship.
Yes.
So that may be taken up, Lordship, another adjournment, I'm paying for adjournment and for the respondent.
So all these cases have been adjourned.
2019.
46 to 48 is different series, Lordship.
No.
We are talking about 29 to 45.
Lordship.
Your case comes in that category, no?
Lordship, Lordship.
So it has been already adjourned.
Lordship.
Take the
2019.
date from him.
2019.
Obliged, Lordship.
So I have a prayer for listing, Lordship, a fresh rate appeal.
You take adjournment in one, you make a prayer for listing of another
It's
case.
a
out
fresh
there.
matter, Lord.
What is it?
Lordship, it's a tender matter, Lordship.
Tender
Lordship-
matter means what?
Lordship, initially what happened, Lordship, when NIT was issued, Lordship, in that both the appellant and the private respondent, they both have participated and they both came out as L1. As there was no clause stipulated in the NIT, so they have taken a method whereby they have adopted a marking system, Lordship. And initially the marking system was taken up and in if we go through that marking system, the appellant comes out as the successful bidder. But again, after subsequently, they have changed the whole marking system to favor the private respondent, as the private respondent is the son-in-law of the chairman, Lordship.
Out of
So
three,
that is the allegation.
that is coincidental, that the
So-
person who has been selected as a concessionaire, he is related to some bigwig. But then after both of you were declared to be L1 and a decision had to be taken afresh, who out of you two, then perhaps some scheme was devised and that scheme must have been made known to you.
No, that the second, when subsequently they have taken
See,
the
out of the
method.
original marking pattern, you two turned out to be successful. Correct?
No, initially, when the marking pattern was adopted, in the first marking pattern, I was the successful person. In the second one, they came out as the successful.
So that marking system, the validity of that marking system was over. Now, whether you were made known prior to the other.
In the
person
second
is
one, we have not given
Any
any.
day next week.
Can it be on Friday, Lordship?
No, it can't be on Friday. It has to go on the date when I come back. Monday,
15. 15/9.
15,
15/9.
not before that.
Hello.
Please, your lordship. Lordship, I beg to mention an IA for listing, lordship. It is for condemnation of delay. Lordship, could the IA be taken up on Friday, lordship?
Yes.
Maybe, Your Honor. My lord, I'll take hardly 5 minutes of your lordship's judicial time. Lord, there is some urgency in the matter. Can it be tomorrow, my lord?
Tomorrow we have many matters fixed. If it could go on 15, we have no problem.
In fact, my lord, what has happened?
What is the matter?
My lord, in fact, the petitioner borrower, he intends to take back, my lord, the secured asset, my lord, mortgage property by liquidating the loan amount. And your lordship is aware, my lord, until the 13(8) notice, my lord, by the bank is issued, he has the right, my lord, of the redemption of the property. Now, the moment the notice is issued, my lord, the writ petition will become infructuous.
Otherwise also 13A,
13(8), my lord,
13A.
yes, or auctioning the property, my lord. Now, till date, my lord, the notice has not been issued, my lord. So I'll take only 5 minutes time of your lordship's, my lord. Deeply obliged.
Yes,
Daily list for this item 2.
In this case, we have.
Lordship, I'm seeking a continuance today, Lordship. Unfortunately, Lordship, they filed their affidavit, but it was with my clerk, Lordship. I just received it today, Lordship.
that's no ground. You should have told that to the Advocate General. He's here since morning.
Lordship, today morning only I just came to know, Lordship.
No difficulty, lordship, only thing that affidavit which we have filed, one subpara was wrongly erased. So we'd like to supplement another affidavit, lordship
Do that.
permits.
Do that.
Lordship,
Do that. We will accept it across the board.
lordship. Otherwise, everything is covered.
File it on a piece of paper, give it to us.
Lordship.
This is for providing potable water to the citizens. Is that the case?
Yes, your lordship.
Clean potable water.
Yes, now that issue is gone.
Okay.
The CAG has raised some objections regarding some financial issues.
Right.
In 2000 up to 2022, we have made that. So that, for that purpose, this affidavit has been filed. But the reasons for delay in executing the projects, the grounds were somehow missed out in paragraph 9. They said the above, the several other miscellaneous reasons as stated below. That's below portion has been not there. So there are 19 grounds. Why
The
they?
supplementary affidavit.
Yes, Lordship, we'll supplement it.
The learned AG submits that in the affidavit filed on the last occasion, few important paragraphs were inadvertently left out. So he therefore seeks the leave of the court to file an additional affidavit supplementing the facts in the earlier affidavit filed. So a prayer for adjournment has also been made on behalf of the petitioner. So let this case come up for consideration on civil subject. Give a date, sir.
24 October.
24th October.
Highly obliged.
Item 3.
Let notice be issued to. Would be the answering respondent.
Lordship. District Commissioner Dubri, Lordship, and Lordship additional
Let
deputy.
notice be issued to response number so and so on steps being taken by the petitioner within a period of 2 weeks, both modes are returnable on so and so day.
Deeply
17. Item 4.
Please, all of.
Yes.
This is coming for the first time. It's a contempt petition, my lord, for violation of an order dated 27th of March 25, my
Where
lord.
do we get the order?
My lord, page 44 is the operative portion, my lord. Page 44, my lord. Para 34, my lord. The judgment and order dated 21/22 passed by the learned single judge in WPC so and so having been set aside, it is hereby directed that the respondents herein shall authorize to the appellants herein the diploma scale of pay of rupees 5,000 to 8,000 per month pre-revised with effect from 1/1/1996 and 12/6/1998 respectively. And thereafter, they would be authorized a revised scale of pay in terms of the accepted recommendations of the 6th Central Pay Commission in the scale of rupees 9,300 to 34,800 per month along with gratuity of.
And you have not been paid.
No, my lord. We have submitted representations as well as a notice from my side, my lord.
The present petition on the present petition for initiating a contempt proceeding against the proposed contemners has been filed for violation of the for not following the directions issued in the judgment and order dated 27/3/2025, passed in WA number 463 of 2023. Let the response affidavit on behalf of the answering respondents be filed positively. The notice to the respondents is accepted by, they are all state authorities, no?
It has to
Is
go.
accepted by who's? Where is Mr. RKD Chaudhary?
I think,
Any junior to him? Available here in courtroom?
Lord, perhaps we
Let a
have
copy of this petition be served on Mr. RKD Chaudhary, learned additional ASJ. ASJ, all right.
much deeply obliged.
2017. Item number 6.
May it please. Lordship, here the IA is for substitution. During the pendency of the contempt petition,
Who appears on notice?
notice already, my lord, was issued, my lord, as per
Has
office,
it been served?
office note dated 28/8, my lord, no AD nor unserved. But it's a substitution.
Awaiting the service of note, awaiting the intimation regarding service of notice on all the respondents. The matter is adjourned to give a date in late September.
Your lordship may direct for Dusty also.
24-9.
Dusty will, on the next date, if doesn't, without
I-
Dusty also, we
Yes,
will
ma'am.
allow that.
I am obliged. ma'am.
Item number 7.
Modification of which one? Which modification? What part of the judgment?
He's for the applicant, my lord. Yes.
Yes.
Where is the order? What modification do you require?
The first IA is for impleting.
Implement. Okay, there's an application, IA number so and so. There's an application seeking implement of the applicants as respondents number 77, 78, and 79 respectively in PIL number so and so. You have no objection?
No, my lord.
The learned counsel for the, whom is the appeal from? The learned counsel numbers outside has no objection. In the applicants being implemented as a response number 77, 78. and
Lord,
79.
subject to correction, my lord, it will be perhaps 84, 85, 86, my lord. Respondents.
Sorry, 84, 85, and 86. So make necessary changes. As per the seriatim in the CIS. As per the seriatim under CIS. A revised memo of parties shall be filed by the applicant in the registry within a period of 1 week, whereafter the registry shall make necessary amendments in the main case. In the records of the main case. I allowed to the extent indicated above.
Hereafter, my lord, one, I am my lord, 2823, my lord.
What is that for?
My lord, for one, my lord, one order was passed on 12/11/24.
The
my lord.
other IA shall be listed on the other day. Let IA number so and so. We'll finish it. Let the IA number so and so be listed along with the main case.
In the main read petition, my lord, in the main read petition, the stand of the state government is yet to come.
Let it come, we'll see on that day.
Because no affidavit has been filed by the state.
Let's
as of-
see on that
Fine,
date.
fine. Much of it.
Bless.
Item number 8.
My lord, the I is for condemnation of delay. Lordship, notice may be issued.
Notice how many days delay? 595.
590.
All notice.
Lordship,
Notice
Oh, okay.
returnable on so and so date.
Lordship.
Full application like much.
2310. Item number 9.
Huge delay. Why even notice? Why even notice? 4,000 days delay. And what grounds have you taken? She has not,
My
what
lord.
grounds have you taken?
At this stage, my lord, notice may be issued, my lord.
No, but what are the grounds? Why such delay? Let us see your application.
My lord.
We can't unsettle things like this, no? And no ground. No good ground. No, we are not inclined to issue notice. We are discussing this application. I is dismissed. Give it to us. Vijay, take it. The other one. Yes, we have rejected. The counsel for the other side need not labor. 4,000 days is something. Unless the issue is very, very great, nothing, and you have not given any grounds. You look a bit dazzled.
My lord.
Or you want to pursue it further?
My lord, at this stage, my lord, notice may be issued, my lord.
No, we might not issue notice. We can grant you some time for you to prepare yourself. Because you look absolutely dissatisfied with the order.
My lord.
Perhaps you are under the expectation, my brother rightly says, that notice would anyway be issued. Therefore, you have not gone through it. We'll give you another occasion, another time,
My lord.
right?
My lord.
But don't make it a habit. As prayed for on behalf of the applicant, re-notify it, so and so.
Similar,
Twen-
so, 10, my lord.
24
But
September.
this affidavit that you filed, this application does not mention any ground. And we perhaps cannot permit you to file another petition. Anyway, we are giving you time.
9
Think
and 10.
about it and tell us.
9 and 10, 24, 9.
My lord.
9. Item 11.
There is a delay of 15 days, my lord.
And the other side appears.
Other side.
Yes, but I appear for all the response.
All the rest.
All the response.
Here, heard the council for both sides application allowed delay control, delay of 15 days control.
Much.
2910, next. Item 12,
May I please your lordships?
43
there-
days delay.
43 days, lordship.
Formally issue notice, we'll.
Lordship.
condone the delay. Only 4 and 5. Here, let notice be issued. There's an application seeking confirmation of delay of 43 days in preferring this appeal. Notice to response number 1, 2, and 3 is accepted by Mr. Bora. Let notice be issued to 4 and 5 on steps being taken by the petitioner within a period of 2 weeks, both modes and tentative on service.
Deeply obliged, lordship.
2210. Item 13.
Yes. One
Under
2 days.
22 days delay, my lord.
Notice.
My lord, and series of writ appeal pending, my lord, for disposal, my lord.
Mr. Khatania,
Yes, madam.
would you like to contest it?
No, madam, in
Let us condone the deal. So and so, heard so and so, condemned.
Obliged.
2910. For admission, item 14.
Yes, Mr.
Yes, may it please your lordship. My lord, the appellant belongs to a reserve category,
Yes.
OBC. And the respondent here, because we are only against respondent number 9. There is no question of an interim order because he has already joined an appointment.
Question of, whether we would entertain your petition.
No, that is why, whether a notice will be issued or not, that's the.
Not required. You argue your case, we'll
No.
consider.
Now, my lord, he belongs to a reserve category.
He
that is
belongs to a reserve.
reserve category. And
Yes.
the respond 9 also belongs to reserve category. Now, there is an advertisement issued by the director of secondary education for filling up a post. Geography, yes. Geography is the subject. And your lordship will kindly note, it is an unreserved category, not reserved category, it's an unreserved category, filling up the post. Now, yes, unreserved category. Now, we participated in persuasive advertisement along with the respond number 9. And there is an office memorandum issued in 2016 by the state. What will be the eligibility criteria, how it will be calculated, selection process, how marks will be calculated. On the basis of that, my lord, I emerge as number 1. 277.17% I got.
And you were permitted to apply against a vacancy meant for unreserved
Yeah.
on the ground that that's an open category.
Yes, correct.
Correct?
Right, absolutely correct. Now, the respond number 9 was lower in marks, but suddenly we came to know that he has been appointed.
Now, there has to be a reason.
Yes, now we went before the learned single judge and we said that how this appointment has been made. And the finding of the learned single judge, there was a state argument before the learned single judge was the effect. They relied on judgment of the Supreme Court NCT versus Pradeep Kumar. Now, in their judgment, Now the judgment is totally, with great respect to the learned single judge, that judgment is completely on a different footing. That says, my lord, that's in a very short paragraph 5, 19.5 and 21. That's the issue before this court. One, whether the reserve category can migrate and participate and compete with an unreserved category. That's number one. Whether he can do it, compete or not. This is one your lordship has to look
You're
into.
not questioning that decision because you are permitted to appear.
Yes, number one, I permitted to appear, I participated, whether now I can be stopped. That is one
Now, we
way.
put it differently.
I'm sorry, my
Now,
lord.
we will put it
Yes,
differently.
yes,
Now, if you don't have the qualification,
yes,
or if you have the qualification which you obtain in TT
yes,
on the basis of relaxed marks,
yes.
then you can't be considered.
Now,
for
now I will give a reply to your lordship. Uh, Now, yes.
Must be Chal Sankar. Just a minute, Mr. Das.
Yes, yes.
It's 367.
I have.
Question number 3, where have you been answered? Look on a different page. This is only with the earlier first question. Doesn't answer. Doesn't answer. The policy decision was contained in letters also issued by the state government, thereby allowing the migration of other category candidates to general category. So far, so good. So it's secured better than general category candidates in the recruitment exemption. All right. This has been criticized by the High Court for a different reason. But the question is, their basic qualification is not there. It is relaxed condition that they can participate in the general category. But this does not answer. No? Let him argue. Yes.
My lord, I'll just give a reply to your lordship's query that has been put forward. Please see the judgment. That's what the judgment of the Supreme Court Vikas Sankla has said.
That is what we are reading.
Yes, see para 80, my lord.
No,
Para 80.
para
Para-
80.
Para 80, if your lordship kindly look into para 80. And if I read that para 80. 80, my lord.
Yes, please read.
Can
the
I
para.
read this para?
Yes.
Having regard to the respective submission noted, I don't know what. This is the judgment.
Yeah, this is the judgment.
Yes, having regard to the respective submission noted above, first aspect that need consideration is as to whether relaxation is that pass mark would amount to concession in recruitment process. The High Court has held to be so on the premise that para 9A dealing with such relaxation in TET marks forms part of the document which relates to recruitment procedure. It is difficult to accept this rationale or analogy. Passing of TET examination is a condition of eligibility for appointment as teacher. It is necessary qualification without which a candidate is not eligible to be considered for appointment. This was clearly mentioned in guideline notification dated 11/2/2011. These guidelines pertain to conducting of TET. Basic features whereof already been pointed out above. Even para 9 which provide for concession that can be given to certain reserved category deals with qualifying marks that is to be obtained in TET examination. Thus, a person who passes TET examination becomes eligible to participate in a selection process as and when such selection process for filling up the post of primary teacher is to be undertaken by the state. On the other hand, when it comes to recruitment of teachers, the method for appointment of teachers is altogether different. Here, merit list of successful candidate is to be prepared on the basis of the marks obtained under different heads. One of the head is mark in TET. So far as this head is concerned, 20% of marks obtained in TET are to be assigned to each candidate. Therefore, these reserved candidates who secure lesser marks in TET would necessarily get lesser marks under this head. We would like to demonstrate it with an example. Suppose a reserved category candidate contains 53 marks in TET. He is treated as having qualified TET. However, when he considered for selection to the post of primary teacher in respect of allocation of marks, he will get 20 marks for TET. As against him, a general candidate who secures 70 marks in TET shall be awarded 14 marks in recruitment process. Thus, on the basis of TET, marks reserved category candidate has not got any advantage while considering his candidature for the post. On the contrary, level playing field is maintained whereby a person securing higher marks in TET, whether belonging to general category or reserve category, is allocated higher mark in respect of 20% of TET mark. Thus, in recruitment process, no weightage or concession is given. An allocation of 20% of TET marks is applied across the
That's
board.
right. So this is in a particular circumstance where the weightage was given to the candidates in the recruitment merit. In
Yes.
the recruitment meriting, I mean
Yes.
listing in merit, where is that situation in your case?
Yes. Now kindly see page.
The Supreme Court has gone on the issue of level playing field.
Now, my lord.
If
Yes.
sans this, suppose it were only an eligibility criteria that you pass
Yes.
CET, but here, if the weightage is to be given, then perhaps you're on the level field.
No. Suppose weightage is given.
Suppose weightage is not given, then
Yes.
would this judgment apply?
No, what I am saying, I will show that your lordship SSC para 47 is a reply. 47, page 47 of the appeal. Kindly see, just keep it in one hand, the judgment.
No, this we have followed.
My lord,
This-
can we just finish the judgment? One paragraph, one more, my lord, if your lordship permits, at para 81.
Yes.
81. Once the vital differentiation is understood, it would lead to conclusion that no concession becomes available to a reserve category candidate by giving relaxation in marks, pass mark in TETs, insofar as recruitment process is concerned. It only enables them to compete with others by allowing them to participate in the selection process. In this backdrop, irrespective of the circular dated 11/5/2011, reserve category candidate who secured more marks than marks obtained by last candidate selected in general category would be entitled to be considered against unreserved category vacancy. However, it would be subject to condition. These candidates have not availed any other.
It's only a sequel of paragraph.
Now I'll just show the question that has been put. Now see page 47 of the appeal. Lordship got it? 47.
Yes,
This is the office memorandum,
yes,
14th of July 2016.
yes.
If your lordship, please turn to page 48 and 5. If you see 5,
Yes.
the criteria for selection of postgraduate teachers shall be as follows. 1, 100 marks on percentage of mark in so and so, 100 marks on percentage of mark in BA so and so. Number 3, 100 mark on percentage. So these are, now please see 5, Roman 5. 100 marks on percentage of marks in TET examination. Now I'll just put it in this way. My TET percentage was 59.5 because you have to qualify 2 subjects. Now mine was 59.5%. The respondent number 5, even he is in OBC category, his percentage of mark, he or she's percentage of mark is 62.5%. So irrespective, now if 62.5, I am 59, I cannot excel over her. Remaining 1, 2, 3, 4, 5 has to be looked into it. That's how it was looked into it by the authority concerned, my lord. This was the case. And the, my lord, judgment of, I am with great respect to the learned single judge, judgment of Delhi High Court is different altogether. They did not recognize OBC category in Delhi. It is only outsider will not be. My lord, if your lordships is like to see the judgment, how it is relied, the Delhi High Court NCT, your lordship is happy? Oh. Pradeep Kumar. exceeded Pradeep Kumar judgment, my lord. Because Sankla also was taken to account. See paragraph 5, my lord. I'll trouble with 3 paragraphs only. See paragraph 5 of the judgment with the learned single judge referred to. On different facts altogether. See paragraph 5.
Yes,
Can I just read, my lord?
yes.
However, the government of NCT of Delhi on the other hand contended that before the tribunal that for claiming benefit intended for the OBC category vacancy in Delhi, OBC certificate must be issued by government of Delhi. Since the respondents are not recognized as OBC in Delhi, they cannot claim eligibility qua the seated criteria with lower marks
That's a
in.
different altogether.
Yes, that's what was considered.
Take up. Heard Mr. Diganto Das, learned senior advocate for the appellant, who has questioned the judgment rendered by the learned single judge dated so-and-so, dated 8/5/2025, passed in WPC number 142 of 2019, whereby the claim of the appellant to the claim of appellant to be the claim of appellant to be appointed on the post of postgraduate teacher in the stream of geography, which was advertised, was rejected on the sole ground that the appellant had appeared against an unreserved vacancy, while she herself was from a reserved category and had obtained TET certification on a relaxed percentage. The learned counsel for the appellant has submitted that in view of the judgment of the Supreme Court in Vikas Sankala and others versus Vikas Kumar Agarwal and others, 2017, 1 SCC 350, the issue has been decided. So, a person of reserved category could always apply for a post earmarked for unreserved category, as an unreserved category post is an open post where anybody could compete with another. The other dictum was that even if in the TET examination, in the TET, the marks were relaxed, making the appellant eligible to appear in the recruitment process, she would have a level playing field, as in the present scheme of examination also. 100% weightage has been given on the marks obtained in TET. So the contention of the appellant is that though she had lesser marks in TET than respondent number 9, who ultimately was recruited, who ultimately was selected, and who had obtained 62.5 marks in the TET, he would not have been disadvantaged, he would not have been put in any disadvantageous position, as 100% marks, 100% weightage on the TT marks had already been given.
Yes.
So incidentally, respondent number 9 also hails from the reserved category.
Correct.
The learned single judge, Mr. Das argues, has relied on a judgment of the Supreme Court in Government bracket density and others versus Pradeep Kumar and others, 2019-10 SCC 120, wherein the issue was different. So the post in question in that case was reserved for OBC candidate, and the applicant therein was not a candidate of OBC, despite having, thus in that case, despite the candidate there having cleared the TET examination with relaxed marks, was not competent to apply for such post, for such reserved post for OBC candidate. Let notice be issued to respondent number 9 on steps being taken by the appellant within a period of 1 week, both modes, returnable on so-and-so date. Mr. Khatania, Learned, what is the standing counsel? And Mr. Khatania, Learned Standing Counsel for the Department of Education, accepts notice on behalf of other respondents. He may also put in his response by the next date.
There's an IA which has been filed. I think
For-
separately IA has been filed.
For what?
186 is only for, there cannot be any stay of the judgment because, no, I will also not press it. What I'm saying, that will be subject to the outcome before filing. I was not the lawyer before the learned single judge. That will be subject to the outcome.
Finally, the IA will be disposed of in terms of the judgment.
Yes, right.
IA, we don't pass any order. in the
Yes,
case.
yes, that's,
The interlocutory application shall be considered along with the main application
yes,
on the next date.
yes, sir.
1610.
I was always of the impression that a person with a relaxed percentage, I was not aware of this.
Yes, when I,
Level playing field,
yes,
that if the scheme of the examination, suppose it were only the qualifying examination and no percentage, then perhaps you would not have
yes, of
been
course.
there.
One judgment where I brought that Honorable Justice Eddie Chaudhary appears in one of the case that Vikas Angla was also placed before the court. I have kept it also. But that is judgment of the Supreme Court, my.
All right, but this
I'm-
would depend on the scheme of the recruitment.
Yes, correct.
Now,
of
if
course.
only it was only an eligibility criterion, then perhaps this argument would not
Yes,
be in your favor.
Yes. And
All right,
deeply obliged.
On 1610. Item 15.
Yes,
May it please the Lordship, Malada, I understand the proposition of law led by learned single judge is absolutely correct. But only on that, when there is nothing prescribed in the rules or by any other means, then the date on the eligibility will be on the date of filing of the application. My lord, here the advertisement, here we have filed before the date of verification. We have shown our documents,
before the date of,
verification of documents. We have placed all the original documents. My lord, your lordship may just turn to the advertisement at page 59. The relevant portions, I will take your lordship to page 62. When there is nothing is prescribed, date of application, my lord, absolutely correct. No second opinion on that proposition of law. Page 62, my lord, they laid down other criteria.
other criteria, yes.
My lord, number 5, no offline application will be accepted in this regard. Number 6, the online application and documents submitted by the candidate will be verified along with their original testimony before appointment. The scheduled date and venue for screening verification will be noted in the official website. Then, my lord, I'll take your lordship to page 63, the relevant.
Yes.
When the candidates appear for the verification of documents, they must produce original certificate, testimonials, documents that were uploaded during application stage.
You have read the punchline.
My lord. And next, my lord.
You have read that punchline.
My lord.
So can you proceed further?
My lord, I will proceed. My lord, I will just, my lord, I will proceed further. My lord. Then, my lord.
See, it is for the consumption of the bar. When I talk like this, that doesn't mean that I am stopping you. This is only a way of addressing the bar.
To put me in lighter zone so that I can place something at least.
Yes.
My lord, I can do my duty. My lord, next, documents uploaded as mentioned below should be colored, scanned, and clear.
That's different.
And my lord, here it says, while uploading and applying online, all documents should be self-attested. So documents has to be given with the online applications. And there number 7 says B.Ed degree. So, my lord, admittedly, I didn't have the B.Ed degree on an filing of an online application. I was allowed by their conduct to go for the examination. I appeared, I passed, I got more marks in the merit position, I was more. And the rejection order at page 55 is only says, only because during the time of verification, page 155, 155 rejected. The series starts there, my lord. 155 rejected as she produced B.Ed certificate issue date shown after the online application date.
2011-24. Right hand side column, page 155. Last but rejected as she produced B.Ed certificate issue date shown after the online application dated 2011-24. Advertisement date, my lord. Advertisement date is 26/12/23. Last date of filing application was 2011-24. Admittedly, I passed B.Ed on 26/12/24.
What
Before
was the last date?
my lord, last date was 2011-24.
2011.
And B.Ed I completed on 26/12/24. Before the online application, I have gone through the final examination. Whether their conduct gives me that scope, because if the rule prescribes, then my lord, admittedly statutory rules or act is there. Here, my lord, nothing is prescribed. But that aspect of the matter, why they have allowed us to appear in the examination. Rejected only on that ground. But they allowed me. I went through the examination. I conducted well. So, and my examination was good. I was in the topmost position of the merit list, first merit list position. But rejected only on that ground. And everywhere it is stated that during online, you have to submit the documents.
I think Ashok Sharma has been reviewed, no?
My lord, it has been.
Ashok Sharma has been reviewed.
My lord.
That's what I think.
Next by the 3 judges benches, my lord. Only, my lord, if your lordship permits me to go through this judgment where it says the crucial cut-off date, if there is in the statute or rules, then that will be taken into consideration. I add one word to that, my lord, if the conduct of the parties, if they allow us to appear in the examination, they knew that there was no document, there should have been rejected at the threshold, that there is no document, you cannot appear.
No, Mr. Roy Chaudhary.
No.
That'll be unfair.
Because there are other merit position candidates who would have applied. That aspect of the matter.
That is the only rationale, no?
Well,
Perfect. It's an open-ended thing.
Well,
We don't know what time would it end.
my lord.
So if your defect is cured,
Then my lord,
the others who thought that they will not be
my lord,
eligible, they have been left
that
completely
aspect of the matter, I could not, my lord.
All right. No, we don't have any.
My lord, I understand, my lord, but
I don't. When it comes, we'll decide. Take it. We have heard Sri Speaker Roy Chaudhary, learned advocate for the appellant, and Mr. N.J. Khataniya, learned standing counsel for the education department. The appellants are aggrieved by the judgment dated so-and-so passed by learned single judges. This court who has rejected the claim of the appellants for being considered for recruitment on the ground that the certificate regarding the basic qualification touching on the eligibility of the appellants was obtained only after the date for filing, cutoff date for filing for depositing application for the purposes of consideration. The short issue which arises in this appeal is whether the appellants would have been allowed to cure the defect, especially in view of the scheme of the examination, when at the time of verification, the documents had to be produced regarding eligibility. The submission raised on behalf of the appellant I mean, how many of you are here?
My lord, around 23.
The submission raised on behalf of the appellants is not justified. It is tried that eligibility for participation in a recruitment process has to be determined with reference to the cutoff date stipulated in the advertisement, namely the last date for submission of applications, unless the rules provide otherwise. The rationale is twofold. First, to ensure fairness and a level playing field by treating all aspirants alike. And second, to secure administrative certainty so that the authority may freeze the field of eligibility on a given date. If candidates who were ineligible on the last date are allowed to acquire qualifications subsequently and yet participate, it would amount to conferring upon them an undue advantage, while others similarly placed but who refrained from applying would stand unfairly excluded. The proposition, this proposition has been laid down by Supreme Court in Rekha Chaturvedi versus University of Rajasthan, 1993, Supplementary 3 SCC 168, and Ashok Kumar Sharma versus Chandrasekhar, 1997, 4 SCC 18. Stop. Though the appellants have secured better than other aspirants, but unfortunately, the eligibility was, unfortunately, they did not have the eligibility on the last date of the submission of the application form. Stop. The appellants had applied against an advertisement dated 26/12/2023, issued by the respondents. They were allowed to appear in the examination, subject to their having the requisite eligibility, which would have been verified at a later stage. The appellants were required to have BA degree, which they had acquired only after the last date for submission of form on 20/11/2024. The degree in this case has been acquired much later. Considering this aspect of the matter, the learned single judge did not agree to allow the case of the appellant/petitioners. We do not find any illegality or perversity in the order for us to interfere with the learned single judge. There is no merit in this petition. There is no merit in this appeal. The appeal is dismissed.
All right.
Item 16.
Wait. This appeal is right in the judgment and order dated my lord 15/7/2015, 25, my lord. What you'll find it starts from page number 62. There's a lot, the advertisement dated 26/11/2019 has been set aside, my lord.
No. What is your ground?
My lord, if lordship starts to page number 60, my additional affidavit, there is the post agent, the Bodo department, where it will be all the professors will from the ST planes, my lord. That had been exempted by this notification dated 1st October 2023. Lordship will see that from the vacancy and the establishment of vacancy of
Which page are you referring to?
page 60, lordship.
Page 60.
Page 60. That particular exemption for the Bodo department for NUS, that has not been considered by the under single judge, making that since this particular college has 3 Bodo.
We can't read this.
Lordship, may I read it, my lord?
Yes.
In exercise of the power.
But if you give a document, it should be legible, no?
Lordship, I am extremely sorry.
You have to give, we can't strain our eyes. Nobody
Lordship,
can.
Lordship, I should have given.
Do you have a typed copy?
Well, this is not a type copy. I'll read it, my lord.
You supply the typed copy of this. This is the only ground on which you will be assailing the judgment.
This has not been considered because.
Well, how do we know what is it? What are the contents?
Well, I'll provide a type.
Supply the typed copy.
Lordship will fix it day after tomorrow.
The counsel for the appellant relies upon a notification issued by the governor of Assam dated 1st of October 2022, which he claims, has not been considered by the learned single judge. Stop. The copy of the notification annexed with the memo of appeal is absolutely illegible. Stop. Let a typed copy, let a typed and authenticated copy of the notification referred to above be supplied by the appellant by the next date. Re-notify after a week.
Lordship.
17:9.
If you want us to read anything, it should be legible.
Item 17.
There are many matters of the same kind.
By common judgment.
It was frightening to see this compilation.
It
I was bound. Huh?
becomes convenient for lordship.
It is convenient. It's
Well,
very easy to do.
Before I take a lordship to the facts, I might just place the provision of law, thereafter I will take me.
All that has been quoted here, no?
I'm
147, 148,
well,
133.
For some convenience, your lordship, I will separately.
I don't think, where is that? See, all the parameters have been satisfied, no?
No, my lord. That's
Why?
why I will try to demonstrate not that the learned single judge has the escaped attention of the proviso itself.
Anyway, it shows the problems.
My lord, your lordship see page 1, my lord.
Yes.
My lord. First, my lord, if the assessing officer has reason to believe that any income chargeable tax has escaped assessment for the assessment year, he may subject to the provisions of section 148 to 153, assess or reassess such income, and also any of the provisions income chargeable tax which has escaped assessment and which comes to his notice subsequently in the course of the proceeding under this section, or recompute the loss or depreciation allowance or any other allowance as the case may be for the assessment year concerned thereafter in this section, so and so. You also see the provision. Provided that where an assessment under subsection 3 of section 143 or this section has been made for the relevant assessment year, no action shall be taken under this section after the expiry of the 4 years from the end of the relevant assessment year, unless any income chargeable to tax has escaped assessment for such assessment year by reason of the failure on the part of the assessee to make a return under section 139 or in response to notice issued under section 1 of section 142 or section 148, or to disclose fully and truly all material facts necessary for assessment for the assessment year. So, my lord, the proviso, if it is read with the main part, my lord, the first is that the income must have escaped assessment. And if an assessment was made under section 143(3) of the Income Tax Act,
Yes.
then no action will be taken after the expiry of the 4 years, unless until the three conditions, my lord, if he had not submitted the return, or the, my lord, under 142(1) or 148, or has failed to disclose truly and fully all material facts necessary for the purpose of assessment.
Yes.
Now, the learned single judge, my lord,
No, but where do you find this impediment in the learned single judge deciding it otherwise?
the learned single judge had not taken into consideration proviso at all. The learned single judge went into only subsection 1.
No.
I'll say.
You tell us whether the situation is like that.
Well, I will demonstrate your lordship, my lord, that.
Let us see from the judgment where has he escaped.
Well, absolutely. That is, I'm demonstrating your lordship, my lord. Your lordship, the judgment starts from page 189.
Page 189.
My lord.
In this compilation, no?
In comparison, my lord. Page 182.
Yes.
And you also may see the finding. My lord, at page 233. It starts from bottom, my lord, to 232, my lord.
Yes.
May I please before lordship?
Yes.
In order to examine the grounds as before the court regarding the correctness of the proceeding initiated it is relevant to refer to section 147 of the Act. The section 147 prior to its amendment in 97 read agenda. So learned single judge Millard first of all quoted the provision which was prior to its amendment. You are also just one paragraph I may read, Millard. The income tax authority, if the income tax authority has reason to believe that by reason of the omission or failure on the part of the SEC to make a return under section 139 or any assessment year in the income tax officer or
to disclose.
truly and fully all material facts necessary for the purpose of assessment. For that year, income to chargeable tax has escaped assessment for that assessment year and thereafter or is there, thereafter you'll also see. Thereafter, the second section underwent an amendment with effect from 149 post the amendment, section 147 read agenda. The first part has been reproduced. The proviso has not been reproduced. Now we'll also see what is in 45. From the above, it is seen that prior to the amendment, the assessing officer was required to have the reason to believe or that the omission and failure on the part of the SEC to file the return under section 139 or the element achievement or having failed to disclose fully or truly all material facts necessary for such assessment, the income chargeable tax has been believed the so-and-so tax has escaped assessment for the relevant assessment year. Then 46 note. However, pursuant to the amendment brought by the effect from 149, the only requirement for reopening the assessment by the assessing officer for reason to be recorded by writing is that the assessing officer is the opinion that income chargeable tax has escaped assessment for the assessment year and that he should assess or reassess such income chargeable for which has escaped assessment and which came to know subsequently. It is evident that pursuant to the amendment brought in the statute from 149, the scope of the reopened assessment is wider than it was prior to the amendment, and this is seen. The assessing officer has reason to believe that income has escaped assessment for the assessment year. He may assess such income in the course of the proceedings under section 47, which the assessing officer has reason to believe. You'll also just skip over and may come to me. Paragraph 49 at page 236. Second part, paragraph 49, paragraph 2. In this context, it again necessary referred to the amendment brought into 147 after 149. Pursuant to the said amendment brought, the only ground for proceeding for reopening of assessment is the assessing officer reason to believe that any income chargeable tax has escaped assessment for an assessment year. In the present proceeding, the information available with the assessing officer is the data available so-and-so to the effect that share capital of the tune of so-and-so has found to be income bogus companies and existed only papers and bogus companies and nothing accommodation available. Cash or commission, they are also may found accommodation. Therefore, this information having come to the position of the assessing officer, the proceeding was sought to be initiated under section 147 by issue of notice number 148. The data made available to the assessing officer by the IIT Kolkata appeared to be the reason to believe for the assessing officer to initiate the proceeding of 147. Pursuant to the approval of the higher dimension so-and-so, next last below 50. In so far as so-and-so, the proposition of effect, the assessee must have failed to disclose fully all material facts and their assessing officer must state so in the regions to be recorded as to where the material fact was disclosed on for the purpose of to enable the proceed for the 147.
And
The further
lively.
for contention material. In this context, it is discussed in the following paragraph that pursuant to the amendment brought in section, the scope and ambit of powers assessing officer 147 has been widened. It is not in dispute that the information available to the assessing officer is on the basis of the data supplied by the Director of Investigation Kolkata regarding share capital raised by the so-and-so. This information primacy cannot be said to be information not germane to a reopening of the so-and-so. Now, the learned single judge had taken the consideration that second requirement is not there at all.
No, the second requirement is once 143 assessment is accepted, then perhaps it can be opened after 4 years. It can be opened after 4 years, but if there is any income chargeable to tax has escaped the assessment or failure on the part of assessee to make a return under 139 or in response to a notice, so on and so forth, and failure to fully and truly disclose. So this 4 years cap, this goes if these conditions are satisfied, which are there in the main section.
In this case, the 143 assessment was made.
Yes.
4 years has expired. And thereafter the reopening proceedings have been initiated.
So that's all right, but unless any income chargeable, why do you have to read the proviso in a truncated form, Mr. Saraf? That is what you, I mean, I don't know about income tax.
I will place before lordship the judgments of the apex court, my lord.
That's true, but let us, before the judgment, let
My
us
lord,
see
I will
this.
show, my lord, what is the necessity, my lord? First condition is that the income must have escaped assessment. That is applicable for all. There is no necessity of, now proviso makes a
Only
restriction.
comes when your assessment under 143(3) has been accepted.
Had been made, then the assessing officer has to see whether such escapement was for failure of the assessee to disclose truly and fully for material fact necessary for the purpose of assessment.
Yes.
Now, the learned single judge had not considered the proviso and has only gone into the first part and said that prior to the 147 amendment, the condition was there, but now this condition is not there. Whereas, my lord, prior to that also, in the earlier
So we have followed, therefore you wish to say that your case would not fall in the category provided the proviso is pressed
my
to
lord,
service.
my lord,
That's what you say.
my lord.
But then the second part of the proviso makes it very clear that even though 4 years have passed by,
Yes,
and if it is found on inquiry or from information and it is true to his assessment, then he can initiate a proceeding.
100%, there is no dispute about
So
it.
therefore, only because he has not written it, the proviso has not been quoted in the discussion,
No discussion, my lord, in the
to
regions,
tell us the facts. So 4 years had passed by,
my lord.
but this information was there. And this was in the assessment of the assessing officer, necessary factor for reopening the investigation,
My lord.
because you are not, that's what I understand
My
from
lord,
the other part.
lordship is absolutely correct, my lord. My lord, the question is that, my lord, the reasons to believe, as your lordship is aware, my lord, on the basis of which the assessment proceedings are initiated, the reasons to believe must disclose that income has escaped assessment, and it was for the failure to disclose the material facts for the necessary for the purpose of assessment. Now, the reasons to believe doesn't say anything about the failure. The reasons to believe only said about the escapement. Now, unless and until the second condition is fulfilled, the Constitution Bench has also said that these two conditions must coexist.
So what is the other condition that you say?
That
Failure
is,
on the part of the
that there was a
assessor.
failure to disclose material facts necessary for the purpose of assessment. If there,
That is the starting point, no?
well, first is that there is escapement. Well, assuming I take it note that there was escapement. But in a case where 143 assessment has been made, then the further inquiry which has to be made by the assessing officer is that whether such escapement was for the failure of the assessee to disclose truly and fully all material facts necessary for the purpose of assessment. Now, in case assuming 143 assessment has not been made, only 143 assessment, self-assessment is made, then this criteria, examination proviso part will not come. Proviso part will come only when 143 assessment has been made. Then the assessing officer has to come to further conclusion that whether there was a failure on the part of the assessee to disclose material facts necessary for the purpose of assessment. Now, if the assessing officer has not come to the second conclusion, when the 143 assessment has been made, 4 years has passed, then it says no action shall be taken in the proviso. So the action cannot be taken unless and until.
Let us see the notice then.
Well, I will show the reasons to believe.
Reasons, the notice.
Notice only says, the 148, that only your reason has been said, because after the reasons are there,
Let us see the reasons.
the reasons I will place before lordship.
From the judgment.
My lord,
From the judgment.
from the judgment, I say give them the copy of the where the reasons of record has been recorded, page 161,
161. all right.
my lord.
Yes, please read.
My lord, as per information, it is found that so-and-so raised his capital to the tune of so-and-so by allotment of shares with LOT, a face value of ₹10 and a premium of 90. As per the information received, most of the LOT company are paper companies which exist only on paper and no genuine business of their own. As per the data preferred by so-and-so, Kolkata, most of the companies are being belong to so-and-so, and so-and-so during the course of his conducted on so-and-so has sworn under oath that he is an accommodation entry provider who provides bogus entries, accommodation entries through the loan, etc. So I have reason to believe that the assessee income amounting to rupees so-and-so for the financial year so-and-so has escaped assessment.
What have you- this- On the end of the reason to. There is an income charging escape assessment. Escape assessment of the assessment. So, so why can't you in this condition come to the last part of the proviso that you fail to disclose fully and truly all material facts?
But the assessing officer must say that this escapement, whatever was there, because 143 assessment has been made, 4 years have passed, it was for failure of the assessee to disclose truly and fully all material facts
So
necessary.
there's a one line, so he says that you have not done it.
My lord,
Now,
the one
is-
line-
Is it necessary for the
Where you said,
reasons to be recorded to say
Yes.
exactly in terms of the section?
my lord, where you said, he had not said anything.
No, escape detention, he says.
My lord, you also may say what he says. Escape assessment, you also may just see, my lord.
It's a very,
You-
it's a line of objection which is too illusory for us to.
My lord, in the,
It's too ephemeral for
my
us
lord,
to understand.
in the, my lord, the series of decisions, my lord. Now, first of, I will come to the escapement also. I will satisfy your lordship on the escapement.
First you satisfy us on this, that this reasons
lord-
recorded under 40 or 4.
My lord, you also may just, my lord, you also may see that where it is. You also may just see, my lord. I have reason to believe that assessing income to so-and-so for the so-and-so income has escaped assessment within the meaning of section 147 of the act. It is a fit case for issue of so-and-so. It might have escaped notice of the assessing officer, who says, but not because of my fault.
So tell us whether you had supplied that information.
My lord, it is here in the accounts.
You say nil.
In the accounts, it is there that previous year this was the share capital and current year this is the share capital. And the Supreme Court says that the
No,
DT
you had given all this information about Narendra Kumar Jain and others.
No, the Supreme Court said that the duty of the assessing officer, the duty of the assessee is only to give the primary facts. Now, inference which is to be done is to be done by the.
That is an information which was there, but you had your notes of accounts. There are the reasons that it is slightly more detailed. That's all you said.
My lord, when I show somebody, I take a loan from somebody, my lord. I
Let
can,
it be assessed, you then file an appeal.
my lord, I've just, that also Supreme Court has said, my lord, that that's what it has been dealt with by the Supreme. I placed before lordship your justice may just whether the appeal is the alternate remedy is the, in this case is or there or not. My lord, the escapement also, your lordship may see what he has
So
said.
one line, if you would have said that all these have not been
No,
disclosed.
that is
by-
otherwise the proviso will have no meaning. This one line is the my lord in taxing matters, my lord, your lordship knows.
Where is your statement in the appeal that you had given all that it had not?
Well, that is the only ground.
Where have you said?
My lord, I'm said.
Well, he's saying something else. He says, his only ground is that in the reasons of 148, he should have said that this was not disclosed by the. Whether it was wrongly disclosed or not, that is not required to be said because the proviso has to be overcome after 4 years, once assessment has been accepted. That's a very thin line which he's trying to make.
My lord, with due respect to lordship, my lord, in the reasons to believe, subject to my lord, in the reasons to believe, he is saying that some person said he is accommodation provider entry and he provides the bogus entries to somebody else, to all companies. Now, a similar case came up before this honorable court, where a company was purchasing cow dung from somebody else. The cow dung from whom it was purchased, a survey was conducted. He said that I have not supplied. It was supplied by third party. A survey was conducted at the third party's office, and he said, I never supply anything. I simply raise the bills.
If this is the ground that you're taking, then there will be no assessment under 148.
My lord, he said that, my lord, that I only provide the entries and take 10% commission from person concerned. On the basis of that, my lord, my assessment was reopened. This honorable court came to the conclusion that this is not escapement of turnover income because he has said that I'm providing the entries. But that does not mean that the entries or bogus entries were provided to person concerned. And these entries which were provided to the person concerned had not been established. Appeal was preferred before this honorable court, my lord. That was dismissed, matter was carried to the Supreme Court, it was dismissed.
When will it be established?
No, it
Suppose
will-
there is an, when will it be established? Only when the, only when assessment is made under 147, no?
No, when the established 147 is for completion, a reopening of the completed assessment.
So therefore, the assessment would be made only under 147, after reopening,
After reopening, yes,
subject to 148 to 153.
my lord.
So therefore, you are challenging the 148 notice.
I am telling the very initiation of the proceedings,
That's right. So 148 notice.
my lord. And that has been set aside in number of Supreme Court judgments on the same ground.
Give us one judgment.
Well, I'm giving, you lost me, just see.
He says that notice itself is bad. It could not have been reopened.
Complaint, yes, my lord.
Give us one judgment, just.
My lord, you lost me, see the compilation, my lord. We start from page 43, my lord.
Starts from page,
43.
yes.
If you lordship permit me, my lord, on this part also, which I was arguing the failure, if you lordship permit me also, I may draw your lordship kind attention, my lord.
No, it shows from here.
Well, in the judgment itself, my lord, I'm showing, my lord.
Yes.
You also may see the section has been quoted. You also may see 762 at the page 48. And the relevant part starts from page 49.
Hmm.
It would appear from the perusal of the provision introduced above, the two conditions have been satisfied before income tax officer acquired jurisdiction to issue notice under section 148 in respect of the assessment beyond the period of 4 years, but within the period of 8 years from the date of the assessment year. One, the income tax officer must have reason to believe that income chargeable to tax had escaped assessment, and that he has reason to believe that such income has escaped assessment by reason of the omission or failure on the part of the SSC to make a return under section 139 for the assessment year to the income tax officer, or to disclose truly and fully all material facts necessary for assessment for that year. Both these conditions must coexist in order to confer jurisdiction on the income tax officer. It is also imperative to the income tax officer to record the reasons before initiating proceedings to as regards the section 148. Another requirement is that before issuing a notice on the of expiry of 4 years from the end of the assessment year, the commissioner should have satisfied the reasons recorded by the income tax officer. It is a fit case for issuing notice. We may add the duty which is cast upon the SSC is to make a true and full disclosure of the preliminary facts at the time of the original assessment. Production before the income tax officer of the relevant account books evidences which material evidences could with diligence have discovered the income tax officer will not necessarily amount to disclosure and so and so. The only disclosure is primary facts. Once it is done, that duty ends. It is for the income tax officer to draw correct inferences from the primary facts. It is for the no responsibility of the SSC to advise the income tax officer with regard to the inferences which he should draw from the primary facts. If an income tax officer draws an inference which appears subsequently to be the erroneous, mere change of the opinion, so and so. You'll also have to skip over and I come to my lord. Page 50, my lord. Para 9, my lord. May I read, my lord?
Yes.
Keeping the above principles in mind, we may now turn to the attention of the facts of the present case. Two grounds were mentioned in the report made by the income tax officer for reopening the assessment of the SSC, respectively with a view to show that the income has escaped assessment for failure to disclose truly and fully material facts necessary for assessment. One was that so-and-so, who was shown to be one of the creators of the SSC, had since confessed that he was doing only name-making, lending. The order passed ground, the other was that the so-and-so and so-and-so, whose names too were mentioned in the list of the creditors, were known name lenders. So far as the ground is concerned, neither the majority of the judges of the High Court nor the single judge who was in the authority relied upon that ground. Regarding that ground, the learned single judge was at the primary observed that no basis had been indicated as to how it became known that these creditors were not name lenders when it was known. The majority so-and-so, in that case, income tax officer, while submitting a report to the.
That's right, we have read that.
Now
But,
you lost
let
me
us-
just,
Let us come to para 8.
para 8 of the
page
judgment, no?
before. Yes.
My lord. My lord.
The grounds or reasons which lead to the formation of the belief contemplated
My lord.
must have a material bearing on the question of his statement from the assessment because of his failure or omission to disclose fully and truly all.
Of his failure to disclose truly and fully all material facts, was there reasonable grounds for the income tax officer to form the above belief? That would be sufficient to close. He must come to the belief, my lord. He has not arrived at the, my lord, that it was for reasons to believe. In the reasons to believe, he is not saying that this was for the failure to disclose material facts. My lord, in the income tax laws, your lordship knows, my lord, that the conditions, as your lordship is fully aware, my lord, that I need not take the trouble, my lord. If the income tax officer was not aware of the provisions of the law, my lord, sorry, my lord. My
Yes.
lord, under the Income Tax Act, so far, my lord, my submission, there is no presumption. There is no equity, my lord.
You can't tax a rupee more.
Now, the question that the Supreme Court in the Parsuram Portal is 107 ITR 76 said, my lord, the taxing authorities are supposed to know the law while they are applying the law. If they fail
What
to
case
do
for
so,
the income tax department?
Mr. Kyal was there, my lord.
We'll only issue notice now. Don't ask for a stay.
My lord, subject to my lord. I am not saying. I am, my lord, your lordship may just consider my prayer, my lord.
Yes, we are not closing it down.
My
We are
lord,
only referring it. I mean,
well,
I just
my
say-
lord, I always find your lordship is always hearing it as your lordship now just now said that we are simply saying that doesn't mean that we will not hear you.
Definitely.
My lord, from the interim, the writ petition, my lord, there was an interim stay. There was an interim stay, the further proceedings will not take place, my lord.
Whatever happens, we'll give a short date.
But the further proceeding, they should not proceed, my lord, till that, my lord. At least that
No
much, my
final,
lord.
no final assessment shall be made.
My lord, that is the only thing, Lord.
That will-
That is the only thing I'm saying from you.
You are junior to him.
Not.
You accept notice?
Not.
File your response, we'll say. Take it up. We have heard Dr. Ashok Saraf, learned senior advocate. For the, how many of you here in this appeal?
5, my lord, the total 5 appeals, Lord.
There are total 5 appeals,
5 appeals.
all taken together. We have heard all the appeals.
Well, I must admit one thing, Lord. I must say, well, I must be fair to the court. Item number 5, 143.3 assessment was not there. But the learned single judge had not considered the 5. He has gone only with the one reasons
So
to believe.
these will be decided.
So that, my lord.
All the items you just make a note.
17, 18, 19, 20.
We have heard Dr. Ashok Saraf and senior advocate in all the appeals. The assail is to the judgment dated 21/7/2025, passed by a learned single judge of this court in several writ petitions, refusing to interfere with the reopening of the investigation,
Assessment.
with the reopening of the assessment under section 147 of the Income Tax Act. The contention on behalf of the appellants is that in the reasons to believe under section 148, no sufficient ground has been mentioned by the officer, by the income tax officer. He has submitted that under section 140, under section 147, he has submitted that the proviso to section 147 has not at all been considered by the learned single judge. under section 147. Under section 147 of the Income Tax Act, an assessing officer, if the assessing officer has reasons to believe that any income chargeable to tax has escaped assessment for any assessment year, he may, subject to the provisions of sections 148 to 153, assess or reassess such income, and shall also, and also any other income chargeable to tax which has escaped the assessment and which comes to his notice subsequently in the course of proceedings under this section, or recompute the loss or the depreciation allowance or any other allowance as the case may be for the assessment year concerned. The proviso to section 147 further delineates that if an assessment under section 143(3) has been made for the relevant assessment year, then no action shall be taken under section 147 after the expiry of 4 years from the end of the relevant assessment year, unless, then write Roman 1, any income chargeable to tax has escaped the assessment for such assessment year by reason of failure on the part of the assessee to make a return under section 139, is underline karo, emphasis provided, or in response to a notice issued under subsection 1 of section 143 or section 148, or to disclose fully and truly all material facts necessary for his assessment for that assessment year. The reasons to disclose page
Please give me 161. 161 Milo.
161.
161.
the reasons recorded under section 148 only provides that a capital to the tune of 1 crore 51 lakhs by allotment of shares with allotment of face value of rupees 10 by allotment of shares existed only on paper with no genuine business, with no corresponding documents. So it was inferred from the data prepared by DIT investigation, Kolkata, that all the companies belong to Narendra Kumar Jain, who during the course of survey was found to have who during the course of survey had sworn an oath that he is an accommodation entry provider who provided bogus accommodation entries, bogus unsecured loans, etc. The assessing officer thus had reasons to believe that the assessee's income of 1 crore 51 lakhs was chargeable to tax for the financial year 2009-10, which was relevant to assessment year 2010-11, which had escaped assessment within the meaning of section 147 of the IT Act 1961. Justifying the issuance of notice under section 148 of the IT Act 1961. Mr. Saraf, learned senior advocate, submits that the proviso to section 147 is very clear. Two conditions are required to be satisfied before an assessing officer acquires the jurisdiction to issue notice under section 148 in respect of an assessment beyond the period of 4 years. Namely, that he must have reasons to believe that income chargeable to tax has escaped assessment. And number two, that he must have reasons to believe that such income has escaped the assessment by reason of the omission or failure on the part of the assessee is underlined karo. Emphasis to be provided. To make a return under section 139 for the assessment year to the income tax officer, or to disclose fully and truly material facts necessary for his assessment for that year. Stop. The requirement under law is that both the conditions must coexist. Thus, it has been contended that the only duty cast upon an assessee is to have made full and true disclosure of the primary facts at the time of original assessment. If that were not done, comma, that only could have been the starting point of reassessment under section 147. Merely because from the nil income slash profit shown by the appellants, it could not have been inferred that no disclosure was made, especially when the assessment under section 143 subclause 3 more than 4 years ago was accepted by the department. Thus, it has been contended. Mr. Sharaf therefore contends that the notice under section 148 is defective, and this was completely overlooked by the learned single judge while deciding the case against the appellants. Let notice be issued to the respondent slash income tax department, which is accepted by Mr. No, your name is?
On behalf of SPKR.
Accepted by so-and-so, junior to Mr. So-and-so, on junior to Mr. So-and-so, the counsel for the income tax department. Let the response of the income tax department be filed by the next date. In the meantime, the final assessment under section 147 shall not be done. In the meantime, no final assessment shall be pronounced. So no final assessment shall be pronounced by the income tax department. Process would continue.
No process, they are already. As you are
We may indicate that the process of assessment may continue.
I'm highly obliged, no?
3rd November. 3rd November.
It's always a pleasure to argue.
It was a pleasure to hear you, Mr. Sharaf. Initially, I thought I'll dismiss this petition straight away.
I'm grateful to last.
That's a very thin line. That in the accounts book, you have said that. This is by inferential logic.
I must say, my lord, always in the income tax matter, there is a thin line, my lord. One is the, my lord, this department,
true.
another.
There is no harm in making a disclosure upfront that I have no idea.
My lord, in all the cases, you'll also find in the income tax cases, so the line is very thin.
Now, but therefore, the equal burden upon you not to take wrong orders from us.
No, nothing, no, never, my lord.
Both of us would not know. Not.
No, my lord, your lordship, immediately, my lord, when reading the section, your lordship, it took me time, but your lordship was just immediately explaining, lord.
It's because
highly grateful, your lordship, lord.
All right.
Item 20.
2022-23, your lordship. And it is from the same order, your lordship, of item 15, your lordship. But your lordship, there is a slight difference between the item number 15 and us, your lordship. Your lordship may kindly take up item 23 first, your lordship.
23 first.
That, your lordship, item 15.
Which all matters are there?
2022-23, your lordship. the item 15 was in respect of, your lordship, B.Ed degrees, which is the basic qualification, your lordship. And so far as we are concerned, your lordship, this is an Assamese diploma, your lordship.
Does it make any difference so far as? principle
Yes,
is
your
concerned?
lordship, this is why, your lordship, this is an additional qualification only for those, your lordship, who pursued their career, your lordship, school career in English medium schools, your lordship. That the purpose of bringing in this additional criteria is to ensure that there is a
Let's see, item number
Lordship.
23.
Honorable Single just took up both these two matters together, your lordship, both B.Ed and Assamese diploma, your lordship, the same judgment covered as, your lordship. Now, your lordship will kindly come to page 101 of my petition. Your lordship will find, your lordship, that
Page 101.
101. This is documents uploaded, your lordship. Documents to be uploaded by the candidates, your lordship. Your lordship will find at the middle portion, your lordship. These are the documents to be uploaded. Your lordship will find passport size color photograph, HSLC marksheet,
This,
HSS.
we are not interested in this.
Lordship,
Let us see the eligibility criteria first.
Lordship, that is, your lordship. Your lordship will kindly come to page 97, your lordship. Minimum educational and professional.
Yes.
Lordship.
Which page?
Page 97, your lordship.
97.
This is, your lordship, for
Minimum educational qualification.
lordship,
professional
for the post of
qualification.
graduate teachers, the candidate must be arts, commerce graduate for postgraduate arts, commerce, having from recognized university with at least 50% marks in either graduation, post-graduation, or Bachelor of Education, B.Ed from National Council for Teacher Education. This we have, your lordship.
Yes.
Before, your lordship, then your lordship will kindly come to page 98. In addition to the academic and professional qualification, your lordship.
So this falls in the category of eligibility criteria.
Lordship. Now your lordship will kindly come to page 98. This is your,
What does it say? In addition to academic qualification as per so and so, a candidate must satisfy the following.
following criteria. In case of Assamese medium school, the candidate must have passed the HSLC or equivalent examination with Assamese language, one of the subject, or have diploma in Assamese language issued by the Assam Sahitya Sabha, or read up to HSLC level Assamese medium school. The object is to ensure, your lordship, that we can, your lordship, properly, your lordship, converse with the students, your lordship. That is the only object, your lordship.
That's a condition, no?
Condition, but your lordship will kindly see, your lordship. That is why I have shown your
And
lordship,
you applied for the post of a teacher in Assamese medium.
Assamese medium school.
What that was.
Lords, we have applied for Assamese medium school, your lordship.
This distinction, you have made good efforts at making this distinction.
Lords,
No, we are not taking first.
that your lordship will find in this, your lordship, page 101, your lordship, the documents pertaining to, your lordship, this Assamese diploma certificate, your lordship, is not required to be uploaded, your lordship, at the time of submission of the application, your lordship. Page 101, that is why I am referring to page 101, these, your lordship, documents to be uploaded. Your lordship will find B.Ed, caste certificate, everything is there, your lordship, except this Assamese diploma, your lordship. Then, your lordship, in 102, your lordship, there is specific condition that the following self-attested colored copies of certificate documents to be submitted online. And there also, your lordship will not find this diploma certificate, your lordship.
How many of you like this?
Lordship, in this petition, your lordship, 34 number of persons.
And persons must have been appointed.
No, not yet, your lordship. The process of document verification is going on, your lordship. We have called for document verification. At that stage, your lordship, having found that,
And you had that, you acquired this degree when?
your lordship, in the February, your lordship, of 2025, your lordship.
That's after the last cutoff date.
Last cutoff. There is no dispute about
Yes,
that.
Mr. Khataniya,
There is no,
there is a distinction made by him.
yes, ma'am, that I understand, but there is no mention about the document which had to upload it in the website.
So
That
therefore-
doesn't mean that
Therefore,
this is,
that doesn't mean anything. That only means that you have given that leeway, that latitude to him to acquire it. On that day, he may not have. You don't say that. That's an additional qualification. It's for you to respond.
yes, ma'am.
Keep a seat reserved for them
Lordship.
But,
if they fall in merit.
there is total number of persons, my lord. And there are 3 read appeal, my lord. Right. Even of them.
34.
We'll decide it immediately.
Lords.
You file your response
Yes, my lord.
so that you don't accuse us of deciding a case on the day when it was first listed.
Yes, ma'am.
Normally, this is the complaint.
Yes, ma'am. My lord may fix it immediately after vacation, my lord, so that we can file our response, my lord.
Consider them, keep the result in sealed cover.
Yes, ma'am.
Take that. A short question has been raised in these set of means. Namely, the acquisition of whether acquisition of such additional degrees after the cutoff date of submission of forms in a recruitment process for which advertisement was issued would prevent such applicants from being considered, especially in the context of no requirement in the advertisement of uploading such certificate online, but only to be produced at the time of physical verification of the documents. It appears from the records that an advertisement was issued by the respondents.
Page 97. 26/12/2023.
On 26/12/2023, inviting applications from eligible candidates for filling up 205 vacant posts of graduate teachers, bracket arts, graduate teacher, bracket science, graduate teacher Hindi, and graduate teacher Sanskrit of the different government secondary schools under the Directorate of Secondary Education, Assam, in the scale of pay of 14,000 to 70,000, including grade pay of rupees 8,700 per month, bracket under pay band 2, plus other allowances as admissible under the rules. The minimum educational and professional qualification for direct recruitment to the post of graduate teachers, arts and science was also specified, which included degree from recognized university with at least 50% marks, either in graduation or post-graduation or its equivalent, and B.Ed from National Council for Teachers Education recognized institutions. S within institutions, by S within bracket. An additional where is that additional criteria?
Page 98, your lordship. At the bottom.
In addition to the academic and professional qualification as referred to in the advertisement, which is in consonance with the Assam Secondary Education Provincialized School Service Rules of 2018. The candidate also was required to satisfy few criteria. Semicolon, one being that in case of in case for application for the post in Assamese medium school, comma, the candidate must have passed HSLC or equivalent examination with Assamese language as one of the subjects, or have diploma in Assamese language issued by the Ahom Sahitya Sabha, or he should have read up to HSLC level in Assamese medium school. The contention of the appellant is that this certification was only an additional requirement, which though was required to be fulfilled by a candidate aspiring to participate in the process, but the cutoff, but no certificate was required. But no such certificate in this regard was required to be uploaded at the time of online filing of applications. The Land Council for the appellants has drawn the attention of this court to the note appended to the advertisement, which lists the documents to be uploaded online after self-attesting those. Out of those 12 documents listed, such certification as referred to above as an additional qualification, which though may be mandatory, has not been mentioned. The only inference therefore is, it has been argued by Mr. Borthakur that the acquisition of such certificate even beyond the cutoff date was required to be accepted. The cutoff date is only for such documents on the basis of which an applicant presses his eligibility, which are to be uploaded at the time of online filing of the application. The non-mentioning of the certification of proficiency in Assamese language is only an additional qualification for which there does not appear to be any interdite in its acquisition, even after the cutoff date. Mr. Borthakur submits that the appellants qualify, the appellants have all the qualifications for being selected for the post, except for the fact that the proficiency in Assamese language, which is only an additional qualification, was acquired later than the cutoff date for filing of such application. But unfortunately, their candidatures have been rejected. Mr. Khataniar, Learned Standing Counsel for the Department of Education, accepts notice and accepts notice to respond to the aforenoted argument till the disposal of these appeals. How many of them? 3.
Lordship, in this, your lordship, 34, your lordship.
Total
Total
34.
42, my lord, in other two.
Other two petitions are one Bengali and one PGT. also.
Tell me about till the disposal of these appeals. Come on. The posts equivalent to the number of the appellants shall be kept reserved. But the process of selection will continue.
Yes.
If at all. If the appellants do not qualify in merit, then there would be no requirement of keeping such posts reserved. Stop. Otherwise, their marks, the marks obtained by them in the final analysis shall be kept under a seal cover to be opened only after the disposal, which shall be opened only after the disposal of these appeals.
And we can complete the recruitment process in respect to other.
The recruitment process with respect to the others can be, shall be pursued and completed.
Deeply.
My lord, fix a date, my lord, so that.
Let these appeals be listed on so and so date.
3110.
No, give a date immediately.
Immediately after. Around 15. 15th of October.
On 15th of October. You file your affidavits,
Yes.
otherwise we'll say.
Yes, ma'am. Oblige, lordship.
Deeply.
Item 25.
Well, this is a common order. उसमें additional qualification add कर दूंगा and Bengali. Either नीचे वाला जो 197 ना उसमें Bengali भी लिखे हैं.
May I please, your lordships.
Yes.
My lord, in this case, I have prayed to quash the illegal notice served by the respondent bank annexer 8, my lord, under section 32, under section 13, subsection 2, my lord, the SRPC Act 2002, illegally against the petitioner,
Your
my lord.
objection has not been disposed of, no?
My lord.
Your objections under 30.
Yes, my lord, not considered, not replied to.
No, has it been decided?
Not decided, my lord, annexer 9. This is filed, not decided.
Who appears for the bank? Bank of Baroda.
Bank of Baroda.
Inform the counsel for the Bank of Baroda so that we dispose it off tomorrow. We'll only ask them to pass a reasoned order. With respect to, beyond that, we cannot. You know the law, no? Name not shown.
Well, notice,
No, we are not issuing notice. Or we'll just issue notice just like that. No further order. Okay, what is your name?
B. Hussain. B. Hussain.
Mr. B. Hussain, learned advocate for the petitioner, seeks a limited prayer of direction to the respondent bank to respondent / Bank of Baroda to dispose of his objection under section 13(3)(a) of the SRPC Act 2002. Stop. Let notice be issued to Bank of Baroda. Let notice be issued to response number 1 to 3 on steps being taken by the petitioner within a period of 2 days. Both modes returnable on. The notice could be served on respondent's dusty, for which also requisites will have to be filed by the petitioner in the registry, whereafter he would be provided copies of notice to be served on the respondents. After service of notice, he shall file an affidavit that the respondents have been served. The learned counsel for the petitioner shall file an affidavit that the respondents have been served. Re-notify given last September.
24
Only to that extent. Only to that extent.
Well,
Nothing beyond.
no, well,
Otherwise, you take action only when something happens in 14, then you go to DRT.
I don't know.
Item 28,
permit. I'm paying for a 1-day time, my lord. Affidavit is ready, my lord. I can file it by tomorrow, my lord.
So these are amendments.
Yes, my lord.
And what is the amendment?
My lord, initially.
This is after the,
No, my lord, before the recruitment.
no, after the advertisement.
Yes,
no.
after, before the advertisement. Before the advertisement.
Before the advertisement, what ground you have?
My lord,
Before the advertisement, what
my lord, in
ground?
the original rule, my lord.
Anyway, you file your
My-
counter affidavit.
Yes, my lord.
Take care. At the instance of Mr. Khatani and Learned, the standing counsel for the education department, the matter is adjourned to
79.
79 forward. I come back. 79.
Obliged.
Obliged.
Chalo.